going? Beautiful. Hi, everyone. We have got some folks joining us, but we are going to go ahead and get started. Thank you for joining us today. We've got a lot to cover, so we're going to jump right in. My name is Catherine Burke, and I'm the Business Development Coordinator for the Chamber. I want to start by giving a quick shout out to our Business Education Series sponsors, Mountain Valley Bank, UC Health, Northwest Data Services, Colorado Housing and Finance Authority, Routt County, and the Wild Horse Refuge. A couple of house cleaning items for everyone. Please switch your chat to everyone so that everyone is able to see your chat. We will also ask that you put any questions in the Q&A function at the bottom of your screen. There's an option to enter questions anonymously. And I am honored to introduce our speaker today, Tina Harkness. Tina is the General Counsel at the Employers Council, a membership organization serving over 4,000 employers across Colorado, Arizona, and Utah with employment law, HR, consulting, and workforce training. With over 25 years of experience, both as an attorney and an HR professional, Tina advises employers daily on the ever-changing landscape of employment law. Thank you for joining us today, Tina. I'll let you get us started.
All right. Hello, Steamboat Chamber members. I'm very happy to be back with you again this year for our annual employment law update. We're going to do a little bit of federal, we're going to do a little bit of case law, and we're going to end with a rundown of what happened employment law wise in the Colorado legislative session, which just ended last week. And some of the bills, of course, have not been signed yet, have not been vetoed yet, potentially. And we might need to follow up with a final, but we'll get you where we are today. So I'm gonna go ahead and share my screen and I'm gonna put up some slides. And Catherine, I'll just have you tell me that everything looks okay once I get this going. Uh,
All right, it looks great on our end.
Okay, perfect. Thank you so much. So I will be sharing these slides. I know somebody probably already put that in the chat. Can we have the slides? Yes, you can absolutely have the slides. I will share that with Catherine and she'll send it out to the group after the session today. Um, so we will just get rolling. All right, this is the lawyer stuff. Please don't share or reproduce these materials without talking to me first. And please don't consider this individualized advice. Of course, this is general information and it could be tweaked or needing to be different for your organization, your specific situation. So make sure you talk to somebody individually about those legal needs that you have, rather than just relying on this. Just as far as trends, you guys know that AI is becoming de rigueur, part of our work life. It's pretty soon going to be uh, working alongside us, if it's not already in your workplace. There is a rather disturbing website that a colleague shared with me about where you can type in your job and figure out when it's going to be replaced by AI. So by next year, you guys might be having an AI do my presentation instead of me. So we'll see how that goes. Um, so we're also seeing some return to office. We're going to have a case on that though, because a lot of things changed for many businesses with the pandemic. And there are many jobs that can now be done remotely that couldn't be before. So we are seeing some hybrid return, not a lot of full-time return. And people seem pretty happy with that. A Gallup study showed that 70% of remote capable employees prefer those fully remote or hybrid, at least, arrangements, and only 30% want to work mostly on site. So you have that switch in our work mentality in our workplaces. We certainly are seeing a rise in AI proof careers, such as those hands-on skill trade work, and of course, the work that requires that intellectual um, thought that goes beyond what an AI can find out there in the world, as far as data that it can report on. Evaluating that for a particular set of circumstances is something that eventually I'm sure it will be able to do, but it's not doing that great with right now. Um, States have for, I would say, most of my career been the main driver of employment law change, Colorado being among the more progressive in the nation as far as what employment laws we might have. Progressive meaning more employee friendly and maybe just more employment laws than some places. When you make if you make a comparison, there are many states that just don't have laws on things that we do, and that a handful of states do. One thing I also wanted to note for you guys is that the federal government are um, they don't do this a lot, but they're pushing for some more nationwide standards in some areas. So the new areas are AI regulation. We'll talk about what's happened with the Colorado AI bias bill that passed in 2024 and where we are today with that. But the Trump administration's been pretty vocal, and there have been several members of Congress that have been pretty vocal about not wanting to have AI managed by the patchwork of state laws that have developed in other employment law areas. That makes it difficult on multi-state employers. Even if you're just in a couple of states, the rules can be different, and keeping track of that is obviously more burden for that business. So AI is one of those places. We have proposed AI regulations in our US Senate right now. Not a lot of stuff is going to happen, I have to say, or generally not much happens in an election year. So we have midterms coming up in November. So attention gets drawn elsewhere. Let's just say that away from some of the proposed legislation. And the federal Congress has a 2-year session, so they have a little more time. Colorado has a 5-month session, so they move a lot faster than at the federal level as well. One other place that I'm starting to see some push towards nationwide standards is in background screening, and a push towards relying upon the Federal Fair Credit Reporting Act versus the state consumer credit reporting laws. So we'll see where that goes. That hasn't maybe gone as far or been as widely covered as the AI regulation, but we'll keep track of it. Oh, for federal. We're in year 2, of course, of the second Trump administration. Certainly, we talked last year about focusing on um, being prepared for workplace immigration enforcement. And that push, beginning in 2025, has continued into 2026. We had an unprecedented historical number of I-9 audits, of ICE raids in our workplaces. So it's certainly important to be prepared for that, especially if you're in one of those industries that is more commonly scrutinized. So hospitality being one, construction being another. I know there's lots of those types of businesses, retail's in there too. Um, just being prepared by having done an I-9 audit, having good practices in place there, and knowing ahead of time, or at least thinking about ahead of time, and maybe talking to your immigration counsel about how should we act and react if we were raided. I know it feels like something that's not going to happen to your business. And at the beginning of this year, ICE announced that they had done some nationwide recruiting campaign and hired 12,000 new ICE agents and officers. So this is a growing area of our federal government, whereas many other areas have been shrinking, and we're likely to see more activity in that area. And finally, in the second year of the second Trump administration, we're getting the agency leadership vacancies filled. So the EEOC, Equal Employment Opportunity Commission, we'll talk about. Department of Labor, well, Department of Labor has had some turnover lately. You might have seen that in the news, but they've got most of their leadership vacancies filled. Some of the other agencies are, shrinking under the gun. The Office of Federal Contracts Compliance Programs is just about gone. The National Labor Relations Board, which enforces our National Labor Relations Act, applying to private employers, unionized and non-unionized, they are much smaller than they were. But with those vacancies filled to the extent that they're now functional, and they're going to start implementing if they have not been able to this point, they're the administration and the Republican focused initiatives. Fortunately for employers, those tend to be more employer-friendly initiatives. You might think differently about some of the ICE enforcement, as far as if that's employer-friendly or not. But many of the other things and some of the things we'll talk about today as changing focus with the agencies are more workplace friendly. This one seems like it would have been bigger news, but marijuana is finally on its track to being reclassified from Schedule 1 to Schedule 3 under the Federal Controlled Substances Act. So the Federal Controlled Substances Act was passed in 1970. Um, it has four schedules of drugs on it. Schedule 1 are the worst of the worst, and marijuana has been on Schedule 1 since 1970 because it was seen as a gateway drug to other harder drugs, more harmful drugs. And I think at that time there was thought that the use was very prevalent. So Schedule 1 means it's illegal to possess it. It is not approved for medical treatment and cannot be prescribed by a physician. Schedule 3 is where the drug is considered to have legitimate medical applications. It can be prescribed, and it is legal to possess with a valid prescription. So that's where we're headed. So December 18, 2025, this is another executive order that is telling the Department of Justice, the Department of um, uh, the Drug Enforcement, excuse me, the DEA to fix this, to get this reclassified. It hasn't been fully finished yet, but it's in process. And the Department of Justice and the DEA have partially reclassified FDA-approved products that contain marijuana and marijuana products that have been manufactured, distributed, or dispensed under a state marijuana license. So, of course, we have many licensed businesses in Colorado who are producing those products. So that just happened at the end of April. For you and your workplaces, just know that recreational use and non-prescribed medical use does remain federally illegal. And even under Colorado's two amendments to allow medical use of marijuana and recreational use of marijuana, employers can and have been always able to, excuse me, prohibit impairment in the workplace. So, so you can absolutely deal with it. If you have a drug testing program and somebody tests positive, you can address that. If you have somebody come to work apparently impaired, you can address those behavioral issues and take action on that. What is changing are a couple of things with this change when it happens completely from Schedule 1 to Schedule 3. The Americans with Disabilities Act has always had an exception for coverage under the ADA for individuals who engage in current illegal drug use. So many of the marijuana-based cases have been kicked under that exclusion. So because it was currently federally illegal, no matter how the state viewed it, the courts had taken that tack of saying then there's no ADA protection for that person. So that is different now, or will be different now. So so marijuana is going to be like any other drug prescribed for medical use. And then prescribed medical use will also likely be protected under our Colorado, and several other states have these too, lawful off-duty activity statutes. So you may remember from 2010, there was an employee who worked for DirecTV in Denver who used marijuana prophylactically to deal with pain issues, but he only used it outside of work, and he at least contended that he wasn't impaired at work. But he was part of a drug testing program. He tested positive for marijuana at that time. He only had a recommendation, right, from a physician to use it for his pain. He didn't have a prescription because it couldn't be prescribed. And his case was also dismissed because it was a unlawful off-duty activity under federal law. So that will likely change. So we'll see what happens with marijuana, but the Department of Transportation, for those of you who have drivers, they're going to have to fix their some of their regulations. They're certainly sticking to the prohibition of marijuana use for pilots and CDL drivers and other safety sensitive roles. They just need to change some of their testing rules um, to for marijuana testing now because it will be Schedule 3. So this just happened in March, mid-March, and this didn't get a lot of press. So it's just something I want to highlight for you all because I said we're in this environment where there's just a lot more ICE activity, including I-9 audits. So ICE has changed its policy on certain I-9 form violations, and they have reclassified these pretty common I-9 errors from technical violations to substantive violations. And just to give you some background, since 1996, ICE has divided violations into these two categories, substantive and technical or procedural violations. So if ICE identifies a technical error during an audit, then it has to provide the employer with at least 10 business days to correct that error before it can fine the employer. And of course, you're going to correct it, right? And not get fined. But when the employer commits, uh, excuse me, in contrast, if it's a substantive violation that they find, they can immediately issue monetary penalties against that employer. So it's not correctable as an error. And there's no showing of good faith that gets you off the hook. So just be aware that these things have changed. There is a fact sheet that has been updated that you can take a look at to have for your reference. The other thing that they do address in the fact sheet is that many of you are using electronic Form I-9 software. The updated guidelines indicate that just digitizing the form is not sufficient. So the electronic system has to have certain features that meet specific standards. So you may want to look at what your if you have an electronic Form I-9 software, you may want to look at what those specific standards are to make sure that it's going to not get you into a problem if you were audited. So, um, moving on. This just came out in the last week. So if we go in the way back machine to 2024, there was a rulemaking by the Department of Labor under the Biden administration to try to increase the minimum salary threshold required for exempt employees. And they were going to step it up in two increments. The first increment was July 1, 2024, and that actually happened. That part of the rule went into place. It increased the weekly amount from 684 per week to 844 per week, and the annual amount from 35,568 for the year to 43,888 for the year. And then it was supposed to go up again January 1 of 2025. And this was a jump from 844 a week to 1128 a week. So that also increased the yearly amount from 43,888 to 58,656 per year. So that second increase didn't happen because in between July 1st, 2024 and January 1st, 2025, a court enjoined the rule. So it said that the Department of Labor had gone beyond its authority in making these increases, that they didn't do it administratively perfectly, all these things. So, so what happened is that uh, this was tied up. This has been tied up in the court system this whole time. So once the court struck it down, the Biden administration appealed it. And it's been in that appeal process to this point. So now the Trump administration has officially abandoned that appeal. They're going to let this die. And we're going to revert to the 2019 rule, which is at the federal level. The minimum salary threshold is 684 per week or the 35,568 per year. Now, the private employers in the room are saying we pay way more than that. And you're right, you do. Because in Colorado, private employers are subject to the pay calc order, and that already requires a higher amount. So for 2016, we're up at that 1,100 a week and almost 58,000 per year. And that, is adjusted each year for inflation. So this 684 per week, the 35,568 per year, that would be a standard for a public employer, public sector employer in Colorado, but not a private employer in Colorado. And it can be the standard that's used in other states that don't have a state minimum salary threshold. So we're continuing, if you are a private employer in Colorado, to follow those state minimum salary levels for for determining if you've met one of the three tests for exempt status. Some EEOC changes. So this is Equal Employment Opportunity Commission. This is our civil rights watchdog agency. They have, in January of this year, approved a resolution to require a commission vote on everything they litigate. So the EEOC can sue an employer on behalf of an employee, and they do that. Obviously, they don't have the resources to do it as much as private plaintiffs do, but they still do a fair amount of that. And formerly, the field office attorneys could make that decision, and the general counsel for the EEOC could make that decision to initiate litigation. So they're going to have very limited authority going forward. And the commission is going to determine what happens with the EEOC's litigation strategy. So it's going to be more centralized, and the agency may push forward more consistently on their priority topics. You won't have somebody in this district who really goes after these cases and in that district who really goes after those cases. And their focus has been on what we used to call reverse discrimination, but we now know there is no such thing, which is discrimination against white males or the majority group, which the Supreme Court made the pretty good point that, well, who's the majority anymore in our current demographic mix. Um, so we're going to see probably less litigation as well. So the priority areas, anti-American discrimination, um, the DEI related work programs that they feel um, give some advantage to different groups based on protected statuses, um, disputes involving the definition of biological sex as only male, female, right? We've had executive orders on that. So this administration has certainly moved away from protections related to gender identity. Um, so this is guidance. We still have case law on the books, right? On in those areas that we're going to follow as employers, but this just tells you where the commission is going to go. They also rescinded their harassment guidance. It took them a really long time to get it out, and then now it's gone. And that is as a result of the gender identity pieces of that are not priorities for the current administration. And then just again last week, um, the White House submitted a plan, or excuse me, the EEOC submitted a plan to the White House to end EEO-1 reporting specifically. So if you are an employer with over a private employer with over 100 employees, um, you're doing an EEO-1 report once a year. And it's a short document, but you have to do a snapshot of your employee makeup at a particular payroll, and categorize people based on the EEO categories. So based on job groups and racial ethnic groups and sex groups. Um, and then you submit it. And usually you don't hear anything more about it. But that's been a requirement for some time. It's also a requirement for um, federal government contractors that have over 50 employees and over 50,000 in government contracts to do that every year. So they're phasing that out. But they didn't say if a report is going to be required this year or not. They haven't opened their reporting window. I'm suspecting that they won't, but that's just me anticipating this because usually we're doing it now, or we've done it already. So we'll see. But they also say they're going to target the EEO-3 reports, which unions do, the EEO-4 reports, which local and state governments do, and the EEO-5 reports for public schools. They haven't gotten to that yet, but they're working on it. Lastly, Department of Labor. This is a good change. Department of Labor announced in June of last year that it's no longer going to seek liquidated damages in its investigations. So pre-litigation or administrative matters. So if you got a complaint that the Department of Labor came in to investigate, um, since I think 2010, the Wage and Hour Division has been more aggressive about going after liquidated damages during wage and hour investigations. So, what are liquidated damages? Well, you can't get, for wage and hour disputes, you can't get uh, compensatory damages for your psychological or mental harms. Um, for the impacts that that has on you as a person, and you cannot get punitive damages. So in the wage and hour world, what you can get is liquidated damages if the agency finds that there's some intentionality or disregard for the law that the employer has shown in that process. So what they will essentially do is they'll take the back pay amount that you owe that person and they'll say, as punishment, we're going to make you pay double. So that's the doubling. That's the liquidated damages. So they're not doing that anymore after 15 years of of pushing for those things. So that is a good thing. You just would owe if you've made an error with someone's pay, you would just owe the back pay under in a Department of Labor investigation. That's not true of a Colorado Department of Labor and Employment Law investigation. Let's just be very clear. The Colorado Wage Act for private employers is very punitive and lots of fines and penalties and multipliers in that law. But if you have a federal claim, you might be in a better situation. And then OSHA announced not long after that they were going to reduce the penalties for employers for violations. So those have gone up. I mean, they're currently $16,500 for other than serious violations. And for serious, they can go up to $165,000 for repeated or willful violations. That's per violation. So, so they've had discretion all this time to do penalty reductions based on a variety of factors. Um, the gravity of the harm, right? The violations the employers had before and its size. If there's been history and good faith shown by the employer, a history of compliance and good faith shown by the employer, they can factor that in. So, and they've always been able to do reductions for smaller employers. So employers with up to 25 employees, they can get a reduction now of up to 70% of whatever the penalty amount should be. It used to be just employers with up to 10 employees who could get that, so really small. So now it's a little bit bigger. Um, and if an employer works to immediately correct a hazard, they can get a 15% penalty reduction off the top. Um, so if the employer has that good record, you may be able to whittle down some of those citation amounts from OSHA. All right, what questions do we got, Catherine or Cece?
Right now, it doesn't look like we have any current questions, but just as a reminder for everyone, you can go ahead and put any questions you may have in that Q&A at the bottom, and there is an option to make those questions anonymous should you need.
Okay, great. Okay, don't be shy. All right, couple cases I wanted to bring to your attention. Um, This Smith versus District of Columbia, I mean, this isn't a surprise, I don't think, to any of us in this room that pre-pandemic, it was a lot harder sometimes to make the case that remote work may be a reasonable accommodation under the ADA because we were all pretty much going to work every day, or most of us were. Now it's going to be a little different situation. So, so this is like the perfect storm, right? Employee who worked remotely due to a medical vulnerability during COVID was later denied remote work as an accommodation due to presence in the workplace being essential. So that could happen, right? The pandemic was a big bad, a very scary thing that we hadn't really dealt with as a human race to that extent in a very long time. So it changed some jobs to remote jobs that really probably weren't done very well remotely. So those may have come back into the workplace, and those can be done or need to be done in the absence of a pandemic from the workplace. But there's a whole lot of jobs that aren't in that category too. And this was a situation where this job, according to this court, fit into that other category. So what was interesting is that, um, she worked remote through 2024. And, so long after COVID-19 was still a concern. And then they made that change. She also received the highest overall performance ratings while she was working remotely. Now, you might say, well, not like you could tell what she was doing remotely very easily. It's a little harder to evaluate people, but she still got them. She still got those high ratings. And there were supervisors that testified that her remote work did not cause a disruption, and that the people they had brought back in to the office, um, didn't have as much sometimes to do in the office. So if you're going to claim that working on site is essential, right? Have that clear, consistent evidence that supports that presence is a requirement for the position. Um, and that remote work history is going to matter. It's going to make it more difficult that in-person presence is to argue that in-person presence is critical. So you want to look at each request. You don't want to be blanket about this. You can't be blanket about anything ADA wise. There is no one size fits all accommodation, and just be aware of this. Oh, so here's another case that just kind of floors you. So I put it out there. We know this too. We've known this for years as HR people, decades as HR people, but the Society for Human Resource Management, lost a suit because they did not respond appropriately to an employee's complaints. So it's just a reminder, and you can tell from this verdict. These are the compensatory damages. So those are to non-monetary harms, right? That people suffer 100 or excuse me, 1.5 million there. And then the punitive damages, which are only available if, again, there seems like there's some intentional or willful conduct on the part of the employer, um, 10 million. So this jury was mad at SHRM and how they treated this person. And, the facts in the article that I read about this case were um, slim, but the allegations were that this employee reported it not only to her supervisor, but to HR, the chief human resources officer, and the CEO of SHRM, and it still was not dealt with appropriately. So just a little cold water in all of our faces that we got to make sure we are always, always, always addressing those complaints and doing a thorough job of it. All right, anything in the chat, Catherine?
Doesn't look like we have any questions yet,
Okay.
so we'll let you keep on rolling.
Okay. We're going to roll into Colorado then. Colorado's session ended on May 13. There's still some carryover to the session. So at the end of the legislative session, Governor Polis has a few options with the bills that have passed. He can sign it. He needs to do that within 30 days of the end of the session. So that's going to be June 12th, right? He can veto it, and he is likely to veto one of the bills we're going to talk about today, or he can allow it to become law without his signature. So it's kind of like the he doesn't have time to get to it, or he doesn't want to sign it for whatever reason, but he'll let it go ahead. So those things will be happening over the next chunk of time. If it's been signed, I've got that noted with the effective date. If it's awaiting governor action, um, he's likely to either sign it or allow it to become law. Polis works pretty closely with the legislature, although they have clashed a little bit more in the last couple of legislative sessions on their priorities. But I would suspect, with the exception of one of them I'll talk to you about today, that they're going to probably get signed or be allowed to become law. So, Colorado's AI bias law. This is the history. Colorado passed what was touted as the most comprehensive AI law in the US. in 2024. Governor Polis signed it with the understanding with legislative leadership that they would revise it in the 2025 session. And they didn't. So they got through the whole regular session arguing about it. Polis called them back for a special summer session last summer, and they still didn't come to a conclusion. The only thing that they were able to get done was kick the can down the road so that the bias law wouldn't go into effect because it was supposed to go into effect February of last year. They kicked the can a little further, or excuse me, February of this year to June so they could have another legislative session to see if they could come to consensus and make the needed modifications. So then April 2026, so this is during our current legislative session, xAI, owned by Elon Musk, sues Colorado over the severe burden the law imposes on AI development. And with the Trump administration's encouragement, the U.S. Department of Justice joins that suit against the state of Colorado. And at the end of April, they put that suit on hold to see if the law would be replaced or amended during the current legislative session. And it was. So in the last few days, I can't remember exactly, but it was in the last week of the session, I think, the replacement AI bill, which is this one, was passed by both houses of the Colorado legislature, and it has been signed by the governor. So it is not effective until January 1 of 2027, but it repeals and replaces the 2024 AI, I should say law instead of bill on this slide. And it's narrowing the focus to automated decision-making technology, they're calling ADMT, versus the broader definition that was in the 2024 bill of AI systems. And this just doesn't affect employment. I'm just focusing in on employment because of the audience today, but this affects a lot more industries than just employment. So be aware of that as well, because you could be affected in more than one way. As an employer and as a business in a particular industry, you could be affected. So this new bill is going to cover that automated decision-making technology that processes personal data. So that's things like name, right, birth date, social security number, those kinds of things, and materially influences consequential employment decisions. So there's a bunch of words there. You know, how material does it have to be? How much does it have to influence? What is a consequential employment decision? So those are the kinds of things that are going to be hammered out, and maybe we'll get some guidance on from the Attorney General's office before this goes into effect. We certainly hope so. I think we can expect that hiring decisions are consequential and firing decisions are consequential. But there may also be things in between that are decisions that have significant impact on a worker. So those of you who use AI to be part of your employment decision-making processes, you're going to be called a deployer, and you're going to be required to provide notice at the point that a worker interacts with that AI. So if it's in the hiring process, that it's going to review resumes and applications that are received. You know, there's going to be some notice in that process, or at whatever point, if you're going to use it in your reviews, or something like that for current employees, then you'd notify them at that point. So there's going to be a notice requirement. Then there's going to be a post-adverse outcome disclosure component, and the opportunity for that applicant or employee to request human review and reconsideration. We'll have to offer it, and someone can take us up on that. Um, so I don't see many employers that are turning their employment decisions entirely over to AI. They may be using AI to increase their efficiencies in that process, or as part of the decision making. Um, so I would just, again, if you are using that, just be aware and be on the lookout for further guidance from the AG's office. Hopefully, they'll give us some direction on the notice piece, the pre-adverse outcome disclosures, right? What all this needs to look like. What's nice about this is there is no private right of action. So individuals cannot sue you if they think you violated this. It is set up to be enforced by the Attorney General's office. So we're going to have a new Attorney General after this election cycle. So I don't anticipate they're going to have a whole lot of stuff out until after that occurs, but hopefully we will get some stuff. Hopefully they will start working on it soon. And we're going to have to keep 3 years of record retention for our use of AI in those employment decision-making processes. All right. This is another AI bill that is still awaiting the governor's action. He's expected to sign it, and if he does, or if he lets it become law without his signature, it will go into effect 90 days after the end of the session, which is August 12th this year. And this has a pricing aspect too that's outside of what we're covering today, but it prohibits businesses from using surveillance data to set wages for workers. So surveillance data could be data that's obtained through an AI, monitoring that person's personal characteristics, their online behaviors, biometrics, those kinds of things. So if you are using AI in your pay, there's still some uses that will work, right? It exempts use of AI to set wages based on work performance or other job related factors. So it could be seniority, could be job duties, could be their generation of new business or those kinds of things. So that would be still an acceptable use. Um, but you want to, again, if you're using it for helping you determine what pay should be, you're going to want to know what's going into that information that it's giving you as an output. Um, so that you can stay clear of letting the AI determine pay, maybe in collusion with what it finds out there in the world of data on what another business like yours is paying or something like that. All right. So we talked about the EEOC thinking about getting rid of or submitting the plan to get rid of the EEO-1 report. Well, the Colorado legislature anticipated this and they passed a bill that is going to require Colorado employers with 100 plus employees, private Colorado employers, let me be clear about that, with 100 plus employees to submit EEO-1 data with their Colorado Secretary of State periodic report. So, although the law is effective August 12th of this year, those reports won't start until after July 1 of 2027. So, and this is required even if the federal government repeals or discloses EEO-1 reporting, which is in the works right now. So we're going to have to do it at the state level, even if we don't have to do it at the federal level. So you got to breathe for a minute and now you're back on. Workers' compensation changes. This is just modernizing workers' comp, if you can believe that. So it's going to allow electronic mailing and filing of documents. So that's a good thing, right? Since that's how we do most of this these days. I don't know how many of you still have faxes going out all the time and coming in all the time. But the Workers' Compensation Agency has worked on that, has worked on older technology, and now they're switching. I also wanted to remind you of another bill that passed in 2025. It's not effective yet, but it's coming. That's why I put this in yellow so you could see that. And that's going to change the rules for who the employee gets treated by when they have a work-related injury. Right now, employers designate physicians and you post them, and employees need to go to those people. But that's going to change January 1 of 2028, and the worker will be able to choose their primary treating physician. And the employer or the insurer is going to need to provide notice to them of their right to choose their provider within 7 calendar days after the employee notifies the insurer or the employer of that injury. And then there will be circumstances where the employer can still, or the insurer can still choose the provider if the worker's, unwilling, unable to do that. This might be getting to the end. So, um, those of you that have unions or have had union activity in your workplace are probably familiar with the Colorado Labor Peace Act. Colorado is what's called a modified right to work state. So the Labor Peace Act actually sets up two elections for before a union can require a worker to pay union dues. So the first election is to get the union into the workplace, and that's usually enough in some states. But Colorado says once the union has been elected, there needs to be a second election to determine if you're going to require all employees to join the union and pay dues. So, in that election, that second election under the Colorado Labor Peace Act has to be carried by 75% of the voting employees on that day of that vote. So that's a pretty high bar. So unions don't like that, right? Because they want, if they've been elected to represent the employees, they want them all paying dues, right? They don't want what they call our free riders that get the benefits of the union without contributing to the cost that it takes to get those benefits. So this last year, um, this this bill passed both houses of the Colorado legislature, and Governor Polis vetoed it. Um, this bill is much the same as the one that was vetoed last year. The only thing that's different is it is the last year of Governor Polis's governorship, right? I don't think that will change it. He's expected to veto this. Um, and we'll see. He didn't veto it during the legislative session, I think pretty intentionally, because if he does veto a bill during the legislative session, the legislature can override it by voting again with a supermajority of the vote to carry that bill. So the session is over, and so we'll see what action he takes, but a veto is expected. And then this heat-related illness piece passed. It the original bill was a lot more involved and detailed. That was similar to what federal OSHA was trying to put together as a heat related standard that has gotten kind of gummed up and stopped at the federal level. So again, Colorado is trying to step in. Um, And the original bill would have been pretty onerous and might have even contradicted the federal OSHA law and could have resulted in some litigation. What they ended up passing was a study situation. And this happens at times with our legislature. So the Department of Labor and Employment under this bill is going to have to collect temperature injury data beginning in 2027 and on or before the middle of 2028 to develop a plan to mitigate heat-related illnesses in Colorado. As our summers get hotter and hotter, sometimes our winters get pretty warm and dry. All right. For those of you who have agriculture workers, so these are people who actually work the land, right? Digging in the dirt, working with the animals, those kinds of folks. Um, there is a new overtime threshold for agricultural workers. It's generally always been higher than the regular overtime requirements for other workers. And I think because these people work a lot of long hours and maybe ag employers couldn't afford overtime at 40 plus hours a week. So it's setting it at 56 hours per work week, and it does increase penalties for employers who don't pay it. That's the commit wage theft. The wage theft term is what is used in the bill, but that's basically what it is if you don't pay it appropriately. Oh, I went backwards. Sorry about that. Let's see. This is the last one. So this is tying business licenses to providing proof of workers' compensation insurance. So this is for construction companies. So it's been a problem that uh, in the construction industry that maybe the subs of the subs of the subs don't have workers' compensation insurance like they're supposed to, and one of their workers gets injured and nobody's paid into that system. And of course it's like our other pooled systems that everybody's got to contribute for it to work correctly. So this is going specifically after the construction industry and saying if you want to get a business license, you're going to have to provide proof that you have workers' compensation insurance for all employees and that your subcontractors also have appropriate workers' compensation insurance for their employees, because that seems to be what has been the most of the problem in the past. So if you're in that construction industry, then you're going to start to see those requirements go into effect. And this one is effective upon passage. It has passed both houses, so once the governor signs it, it will go into effect. But I imagine it'll take the different licensing agencies some time to respond to this. They don't work in a blink of an eye. So you'll probably start to see that request for that proof of your insurance, like a certificate of insurance, um, or something of the like, when you apply for your business licenses. All right. I think I got to my hour. That's all I have. I'm going to stop my share so I can see Catherine's
Hi. Yeah, we have
face.
one question in the Q&A
Okay.
for you.
Okay.
Um, for those of us that work with independent contractors, is there anything we need to be aware of for this year?
They changed the federal test. They went back to the economic realities test, which is what Republican administrations typically favor. So you're looking at the multi-factors and you want the teeter-totter to weigh heavily. But Colorado's test is more rigorous. So if you're meeting Colorado, you're going to meet the economic realities test for for the federal government and the different agencies that need information? It's a good question, Marjorie. Why do some laws become immediately effective and why not? So, both the federal legislature and the state legislature have the option of making something immediately effective. They call it a safety clause. So they're basically saying this is so important for the health and safety of our citizens that this goes effect as soon as it's passed. For everything else, um, it's either going to be 90 days after the end of the legislative session. That's Colorado. That's the August 12th date. That's where most of the stuff falls. Or they're going to set a specific date down the road because they anticipate that there's going to have to be some work done in between then and now, and that they don't want to make it immediately effective so that businesses can prepare for it. So that's the AI bill. Um, that's the demographic reporting. That's the surveillance data stuff. They're setting that up for a little farther down the road. So, I mean, thankfully, so we can get ready. I mean, it's not always a lot of time. It's not always enough time, but it's some time. So it's what they think is the need. Um, and it depends on what the bill is trying to do. You're welcome.
All right, it doesn't look like we have any other questions.
Okay.
So we will go ahead and close everything out. Thank you all for participating and engaging today. Thank you so much for joining us again, Tina. I will be sending
Yep.
out the slides and the recording of this session tomorrow for everyone to have. If you have additional questions that you weren't able to get into the chat today, please don't hesitate to send them my way, and I can help facilitate getting them answered. Before we leave, I'd like to highlight just a couple upcoming chamber events. The Summer Business Showcase is scheduled for June 17th from 5 to 6 p.m. at Yampa River Botanic Park. Join us for an engaging outdoor networking event celebrating the best of Routt County's summer businesses, nonprofits, and experiences. Exhibitor registration is open now. And then I would like to invite you to join us for our next virtual business education session, Estate and Succession Planning for Businesses. That is going to be held on June 24th from 10 to 11 a.m. via Zoom. Thank you all again, and I hope everyone has a wonderful day.
Thanks, everybody.